other things too. And Jonathan and I go way back to fighting some of the biggest battles in copyright infringement and plagiarism around as the web and web publishing developed. And he is one of the world's leading experts as a citizen. Well, I mean, you're my pirate. You're my copyright pirate. You're the plagiarism king of the world with this. With over 15 years experience, he's working with rights holders, large and small, battling in the courts to help protect copyrights for web publishing content, for apps, for anything that deals with copyright infringement and with plagiarism. His site, Plagiarism Today, has published over 4,000 articles about content misuse issues. He's a consultant, and as I said, he's a expert witness with all of you. Suede A, if you could take a seat, that would be awesome, and that'll keep you from being removed from the event for looking suspicious. All right, fantastic. And he is not only an absolutely dear friend from down in Louisiana area, but he is truly one of the most, I don't even know how to say this without bursting into tears, because this is how proud I am of everything you have done. He changes people's lives by helping people, giving them a voice and an opportunity to protect their intellectual property. Now that's a big word, but what it is protecting your original work, your original art, your original words. And he started out defending his own poetry from that and his own writing, and he continues to fight, and he has saved my career many times. So I want to thank you and welcome to the stage the amazing Jonathan Bailey. Everybody give up some love, some VR love for coming up and doing this.
Oh, thank you.
Yeah,
that is hands down the best intro, and I fear that you completely overhyped this. I'm so
course
sorry.
I have.
I'm in a disappointment, everyone. I'm just so sorry. First off, apologies. I am in 2D world. The only VR headset I have is not compatible with AltSpace. I have a PSVR, but hey, I want it free from Taco Bell. So, I'm not going to complain too hard. But anyways, the talk today, as you can see, is copyright and VR. Copyright, and also we're going to discuss toward the end a little bit about plagiarism as well. The two things are definitely connected. But for now, we're going to put most of the focus on copyright. So let's see if I can actually get the slides working. And I can. All right. First things first. What I hope we get through today, I'm going to try to get through everything pretty quickly. First, we're going to talk quickly about me, even though Laurel just literally blew any introduction I can get out of the water. Then we're going to talk about the basics of copyright, how it applies to VR, how not to get sued, which is a very good idea. No one wants to get sued. And then how to protect your work, what you need to do to protect your original creations from being infringed. Then steps you can take today, and in fact, as we'll discuss in a few minutes, steps you'll probably definitely want to take in the next month or so to make sure that your work is as safe as you can make it. So on that note, and you see I did it right away. Can everyone still see the slides? Because I knew I was going to do that. All right, slides are still good? All right, cool. All right. So real quick, a bit about me. My name is Jonathan Bailey. I run the website Plagiarism Today, which is a blog I started back in August 2005. The date is somewhat significant because I live in New Orleans, and if you happen to remember anything about New Orleans history, you might remember we had a spot of bad weather around that time, so you can think of the blog as a Katrina baby. For years before that, though, I had been doing copyright work protecting my own content. As Laurel mentioned, I started this out as a poet and short story author. I found over 700 people plagiarizing my work, and I started Plagiarism Today as a means of chronologing that and discussing the tactics and things I was using and where I was having success. It's about 10 years ago, so 5 years after the creation of the site, I launched copybyte.com. Well, actually, I started getting into consulting. Copybyte.com came later, but copybyte.com is my consulting firm. That is where I do my expert witness work. I do content enforcement, DMCA takedowns, things like that. Basically, if you got a need in this space, get in touch with me. If I can't meet it, I know someone who can. I know a ton of lawyers. I can definitely help put you in touch with someone if needed. And like I said, 15 plus years of experience in this field, lots of time and lots of sanity lost, and a lot of very lonely nights of not getting invited to parties because you get known as the copyright and plagiarism guy. Doesn't get you invited to a lot of parties. But yeah. However, one fact I do want to impress upon everyone, I am not a lawyer. I'm very knowledgeable about the law. I think I've earned the right to say that, but I am not a lawyer. Nothing here is legal advice. Please feel free to consult with a lawyer if you so choose. So, next. All right. Yeah, I have to do a weird teleport after each, and we skipped a slide. Poops. No, we didn't. Oh, okay, anyways. Hang on one second on my end. I apologize. My slides are out of order on my phone. Yeah, my slides are out of order on my phone. That's the problem. I must be using a different version of it. Hang on, that's the issue. You know what? We'll just run with it. All right. So the definition of copyright. We'll start there. The U.S. Copyright Office, and this is like the only slide I have with a lot of text on it, I promise, Laurel. I know you're going to kill me for putting this up here. I read the speaker packet. This is how people get murdered at this conference.
Yes.
Copyright is a form of protection provided by the laws of the United States to authors of original works of authorship. So, long story short, what that means is copyright is a set of laws, a set of protections that creators obtain over their work. And that means a lot of different things, as we're going to go into. The long story short is the important things to remember is that it's literally provided by U.S. law. In fact, it's actually baked into the Constitution, and it protects original works of authorship. And we're going to get into that definition in a minute because it's kind of important. But yes. And while we're talking about things that are important here, United States alert. I know that this is a more international, more global conference. Different countries have different rules, different regulations. In fact, we're going to be talking about the U.S. Copyright Office in a minute. If you are not in the United States, congratulations, you can fall asleep during that part. Perfectly free to. But long story short, we're going to be centering this talk on the United States law, A, because that's my area of expertise, but B, because we only have an hour and not like, an entire semester to discuss this. So, sorry for that. So, that brings us to the question of what does copyright protect? Well, copyright protects creative works fixed into a tangible medium of expression. That is very important to remember there because it's creative works, specifically works of creativity. And by the way, the threshold for works being creative enough is stupid low, as we'll get into in a second. You can actually protect just about anything, oddly enough, if it has even the most residual spark of creativity. But it's the tangible part of that that gets very interesting, because it must be fixed into some kind of tangible medium of expression. So let me quickly give an example here. I'm up here flapping my gums and telling you all these wild stories and making all kinds of great jokes that I'm sure everyone's laughing at. But no one's fixing this. This is not being, Laurel is, there's a camera in the room, but I'm not fixing this. I'm not recording this. Now, if I were not recording this, what I'm doing would not be copyright protected because this is just going out into the ether and is disappearing. Nothing to copy, nothing to protect. Pretty straightforward. Meanwhile, if you write it down and say you make a doodle on a napkin, say you save a file to your computer, you have protection on that. It's that modicum act, it's that tiny little skosh of an act of saving it in something that can be copied or somehow physical that doesn't. It also is interesting that a creative work is identified as a wide variety of content. It's literary, musical, dramatic, film, photography, boat hull designs, I'm not making that one up, architecture, a lot of random things. Worth noting also that in the United States, copyright is federal protection only. What does that mean? It means there is no state copyright law. There used to be okay, I speak a little bit in extremes there because of pre-1970, but in general, it's federal only. You can't go to a state court to sue for copyright infringement because it is a federal only statute. Anything you're creating or working on in this space is going to be a federally protected work. And finally, the copyright of a work transfers to either the creator or the employer. Now, whether you're an employer or not, that gets more into employment and HR law. And if you want, I'll gladly have my girlfriend come in here who's worked in HR and explain the difference. But long story short, if you are an independent contractor, the 1099 generation and all that jazz, congratulations, you retain the work you make. Now, contracts may be signed that transfer copyright and other things, but without such agreements, and those agreements have to be done a very specific way, you retain everything. And also, likewise, if you're paying someone for a work, but they're not your employee, without some kind of pre-existing agreement to transfer the rights, the person who creates it owns it, even though you paid for it. So it swings both ways on that. Okay, so what does a copyright not protect? Well, first and foremost is it does not protect names, nor does it protect slogans. That is a matter of trademark protection. That is a completely separate law with completely separate rules, regulations, standards, diddly-diddly-dee. Likewise, it does not protect ideas or procedures and systems. Those are covered under patent law. Patent law, once again, a whole different set of rules, ideas, procedures, diddly-diddly-dee. Third, it does not protect works made by the U.S. federal government. This is a really interesting kind of quirk, and it's something that's fairly unique to the U.S. In the United States, any work by a federal employee as part of their job is automatically placed in the public domain. Nobody gets to claim ownership of that. So everything from top secret documents created by the Pentagon, for example, though those have other protections, obviously, to those beautiful space photos from NASA are completely free to use, whatever you want to do with it. Find it in any number of public domain libraries. Now, this does not extend to states. There's actually a case before the Supreme Court right now in which the state of Georgia is trying to tell people that it has the right to enforce copyright on elements of its state law. Now, if that sounds like they're being big fat jerks, that's because you're right. They are. That is pretty mean. So, long story short, it does not apply to states or local governments, but federal government cannot claim protection in their own work. It also doesn't apply to fashion designs, which is very interesting. Ron here has a very smashing hoodie on right now that he's that I absolutely love. Hoodies cannot be protected by copyright. Hoodies cannot be protected by copyright because it is considered a useful article, and as a result, it just doesn't qualify for protection. Now, his hoodie has I believe that's an owl on it, Ron? Is that an owl? The drawing of the owl would be protected by copyright because that is something that exists independently. You can put that in a painting, you can put that wherever you want, and it qualifies as artwork completely separate from the fashion. But like the cut of a dress, the style of a pair of shoes, for example, can't be protected by copyright. And the final thing that it doesn't protect is works without a requisite level of creativity. That includes the phone book, interestingly enough. There was actually a major copyright case about this in which the courts ruled, when the Supreme Court was a district court, but it ruled that even though it takes an amazing amount of labor to assemble a phone book, you got to go around and get all these phone numbers and do all this crazy stuff. It takes an amazing amount of labor to do a phone book. It's not creativity. It's just a bunch of names and numbers assembled together, and that's the result of it. Basically, since there's no creativity in assembling it, there's no copyright protection. So yes, those are the things in which copyright. So just a short list of some of the things copyright cannot protect. I'll come along with you. All right. So, what are the rights copyright grants you? Well, there's a whole series of them. We're going to go over the 5 big ones. First off, it's the right to reproduce a work. That should make a great deal of sense. Copyright literally has the words copy and right in it. Therefore, ipso facto, it is the right to copy a work. It just makes sense. So yes, the copyright holder, whether that is the artist or their employer or whoever otherwise obtains said right, has the exclusive right to reproduce that work. Next, it is the right to create derivative works. This one gets a little more complicated, where the right to copy is much more simple. This one gets much more complicated. J.K. Rowling is the only one, for example, who gets to create sequels to Harry Potter, at least until her books lapse into the public domain. She holds the copyright in Harry Potter, and therefore she gets to write sequels. There was actually a case in a lawsuit where someone tried to create an unofficial encyclopedia based upon it, and J.K. Rowling won that case. Now, this also covers not necessarily sequels, but it covers that people might come along and want to make, Schmerry Schmotter and the Intellectuals Brick, or something like that. It's obviously just Harry Potter with very bad thesaurus use. That too would be covered under this. It's basically, the standard is any time in which it is clear to a layperson that A came from B, it becomes a derivative work. And that, like I said, it enters into a lot of gray area, and there's actually a lot of case law here. But basically, if it's obvious to a layperson that these two things are derivative from one another, it's a derivative work. This is an interesting one, the distributor work. It's like, wait a minute, didn't we talk about copying it already? Why would you copy without distribution? Well, it's interesting you'd ask that, because even though this was passed and this was codified way before the internet, it actually came into play a lot on the internet. Because when you watch a video on YouTube, for example, you're not necessarily making copies of that video. However, they are distributing the video. So if that video is an infringement, it runs into copyright trouble. So it was intended for very different situations in which people were, obtaining copies of a book before release and distributing them and things like that. But it's become very useful for rights holders on the internet to deal with very 2000s to 2010s and 2020s now, geez, where did the time go, issues. Publicly display and perform a work. This is to distribute a work. My phone's out of sync again. Sorry about that. To distribute a work. No, that was right. First, public display, perform. Thought I put that right. Sorry, still getting used to the slide system. Bear with me. Publicly display and perform work. Very similar vein here. But let's say, for example, I came up here and started performing music from Wicked. Everyone will leave because I can't sing. But also, it would be a public performance because we are in a space that's not totally among my friends and family, for example. And also, there's at least some commercial component of it because even though we're all here for free, I guess you can argue I'm promoting my business or whatnot. So that would be a copyright infringement. A common use of this is how playwrights prevent theaters from using their plays without permission. And you run into this a lot also with movie theaters. They have to obey this right in order to show a film in their theaters. All right. Everyone's favorite topic, the limitations of copyright. Now, copyright may seem like a pretty extreme right, but especially in these United States, it actually has a great deal of limitations placed upon it. Long story short, the biggest and the most common you'll hear about is fair use. And fair use is actually something that it's on the laundry list of things in which if I were going to, just do an hour on one slide or one line of a slide, I think fair use would probably be on it. The reason is because fair use is extremely complicated and extremely detailed and also extremely nuanced because basically anyone who tells you definitely that something is or is not a fair use is probably misleading you. And the reason for that is simply because the only people who can make a determination of what is a fair use is a judge and or a jury. And the result of that is the only way to know if something is a fair use is to go to court, get sued, and deal with it. Now, there are 4 factors to fair use, and those factors are the purpose and the character of the work, which basically identifies in this context what are you doing with the work. In 2020, that comes to meaning the word transformative, i.e., is your work sufficiently different from the original work? Second, the nature of the copyrighted work. That deals with whether the original work is either published or unpublished, or how long has it been out, for example, and those types of issues. The third is the amount and substantiality of the portion taken. This and the one before it really aren't weighed that heavily, but they're worth noting. And the fourth one is the effect of the use upon the potential market. I don't want to get bogged down on those because, like I said, that's a whole hour conversation. But you can see how those factors are very, very ambiguous. And long story short, two very, very reasonable and intelligent people can have very, very big disagreements about it. The second main limitation of copyright is expiration. Once again, in the United States, copyright expires 70 years after the death of the creator of the work of individual authorship. So basically, what that means is all the people who want to use your work for whatever other purpose are basically waiting for you to die. That's your morbid thought for the day. The whole world is waiting for you to die so they can use your stuff. Yes, it's life plus 70 for creators, and if you happen to be a corporation with I'd be very impressed if you personally happen to be one, but works a corporate authorship, for example, if you do something for your company, that's just a flat 95 years. So, next up, we're going to bring this to VR. And the long story short there is there's 5 key areas where copyright intersects with VR. First is the software powering VR. Second is 3D models. The third is other content that gets brought into VR. The fourth is what I'm doing now, which is an action self-performance in VR. And the fifth is I want to add a little additional bit there about music in VR, because that's a slightly separate issue that you probably need to jump in on. So, we'll start by talking about software, specifically the software used to power VR. Interesting fact, software is protected by copyright. Okay, that really seems logical, but it's only been that way since 1974. Now, anyone who knows the history of computing knows that there was a heck of a lot of computer programming going on before 1974. Punch cards and neat stuff like that. None of that was protectable by copyright. And the reason was, according to the U.S. Copyright Office and other powers that be at the time, it was basically a complicated math equation. And you can't copyright a math equation. Finally, some people actually talked sense into the powers that be, and now, and ever since 1974, copyright has enjoyed protection, though realistically it's only been since 1980, the Atari age, that it's enjoyed full protection. Because, those video games don't need any copyright, right? They don't need anything like that. That's silly. Don't be crazy. Some of you may have heard about a quick show of hands. Some of you have heard about the ZeniMax versus Oculus lawsuit that's been going on. Anyone familiar with that? That's not going on. It's completed. Okay, so a few people. Long story short here is the basically, once again, this could be a whole hour into itself. ZeniMax is a video game development company. They're well known for games like they've been attached to games like Doom and Quake and so forth. They have a long history in the 3D space. And Oculus briefly had a relationship where they were working together on getting into VR. John Carmack, the former head of ZeniMax, eventually left and went to Oculus to try to develop that technology. And what happened was a legal battle in which ZeniMax sued Oculus for both stealing of trade secrets and copyright infringement, and ended up, district court ended up ruling in favor of ZeniMax, saying that there was indeed theft taking place. And basically, before they got to the seemingly inevitable appeal, the two sides settled. There is indeed copyright in software that powers VR, and there's already been one legal battle over it because, of course, there has. Another interesting area of copyright to note is software development kits, which include APIs. application programming interfaces. This is the subject of the ongoing Google versus Oracle one. I'm sure some of you have heard of this as well. This is a lawsuit in which Oracle is claiming that Google, when Google went to make the Android mobile operating system, lifted the APIs from Oracle Java and took those and made it so that Java programmers could easily move their app onto Android. Oracle sued saying, hey, you can't do that. That's our copyright protected code, diddly diddly dee. And Google made two separate arguments. One was that APIs can't be protected by copyright. The second was that, oh, well, even if it is, it's a fair use. Now, Google won both times in the lower court, but both times Oracle appealed and got it overturned. And now now the whole kid and caboodle just got dumped at the feet of the Supreme Court. In fact, they just had the last of the amicus briefs filed today, I believe. Yesterday. Wednesday was the last day. And long story short of it is, we will know a lot more about this probably in October or so. Stay tuned to this space. So 3D models are fascinating because 3D models, even though there seems to be sort of a Wild West attitude about it in general, 3D models are indeed protected by copyright. This makes a ton of sense, though, if you think about it. If a digital photograph is protected the exact same way as a physical painting, why wouldn't a 3D model be protected the same way a physical sculpture is? It's pretty logical. So yeah, just like paintings and sculptures, they are protected. So if you're going to use models to create your 3D world, to build something that you want to create, you need to license them in order to copy them and use them. Now that said, one of the great things about this space is there are tons of open source and open license models here, places that you can get these models from. And so there are tons of resources out there. I mean, I'm not a super expert in that particular field, but even I, with just a few quick Google searches, found some great places to pull 3D models from. And also the other side of that coin is anything you do create is protected. You have full protection over everything you make. You do not have to tolerate people using or selling your models. You can defend your work, and I'll show you a bit about that just a little bit later. All right. So other visual content. Similarly, 2D artwork is also protected. If you see my slides and you see all these lovely paintings artwork over here, these are protected by copyright. Paintings, photos, etc. If you're going to use those, you need to license them as well. And there's tons of great resources for that. You can get public domain stuff, open license stuff, etc. Just to drop a few names here for you to use later. There's Pixabay is probably my current favorite website for getting free stock photos. It has a very, very good library of photos that you can just put anywhere, literally. Pexels, P-E-X-E-L-S is one, and also Wikimedia Commons, which is by the same people that do Wikipedia. In fact, it's how they organize the artwork for Wikipedia. They have an amazing library of everything from public domain to Creative Commons, stuff that you can use pretty much anywhere you so choose. So it's a great, great collection there. Actions and performances in VR. I say this and I'm going to, bounce around the stage a little bit just to emphasize action. Yay! The things you do in VR are typically not protected. If it's not being recorded, if it's not being fixed into that tangible medium, it is not protected. Now, this is being recorded. I don't know where our camera went. Oh, there you are, way up there. This is being recorded, so this recording will be protected. But then complications do arise, because here we have multiple creators in this work. The wonderful team at this conference designed the slides, so they have copyright in that, but I have copyright in the words that I put on those said slides. They may have copyright to the recording since they had the creativity to stick the camera way up there in the rafters. That's now very disconcerting now that I've noticed it. Don't hurt yourself, little buddy. But yeah, the long and short of it is there's complications there because there will be multiple creators in that. Because the fixed elements, the things that are fixed, are still protected, and therefore do enjoy some degree of protection. Boop. Like I said, still getting used to the space. So music in VR, I wanted to call this one out especially because this is probably, I predict this is going to be a challenging area in the not too distant future. Music has always been in internet the canary in the coal mine. Remember that the first lawsuits over internet piracy were over Napster, the first big ones? That's because music is the canary in the coal mine. Music is easy to share, and it also has incredibly stupid, complicated licensing. Oh my God. All right, moving on. Don't hurt. I'm gonna run myself into a wall here. Long story short, music in VR is protected, and this includes both everything that you compose, but also things that you bring in. So if you bring in things, you need to make sure that it is correctly licensed. And likewise, if you do compose things or perform things in VR and it is recorded, you have protection over that. Now with music, there are two licenses to worry about, and this is the short version of this. There are two licenses to concern yourself with. First is the composition. The composition details everything that was written on paper. That's the notes, that's the lyrics, that's the diddly-diddly-dee. The recording is the audio file. That is whatever was laid down in an MP3 or AAC or what the cool kids use. Spotify. It's put in that Spotify. That's what the cool kids use, right? But yes, long story short, that is anything you hear versus anything you see. Each of those have separate licenses. Now, in these United States, there is no public performance right for a recording. I know, that's confusing to me too. But there is a public performance right for the composition. I know, I'm confused too. But really it only matters in this context if you're either distributing the track somehow, for example, offering it as a free download in VR space, I don't know why you would do that, or you're using it in a way that would constitute a public performance. So if you're using it as part of like a VR business, or if we were piping in, some safety dance here, that could be an issue as well. And now I've got the safety dance. Hey, great move, Jonathan. Very, 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 very good move. But yes, long story short, it's mostly only an issue for public performances or distribution. So, how not to get sued? Isn't this really the $10,000 question? No, literally, it's the $10,000 question. Because because a lawsuit, even a minor copyright lawsuit, will cost you at least $10,000. So nobody wants that. The good news is litigation and action dealing with VR are very, very, very uncommon right now. A lot of that's because this space is still very new. We're not seeing a whole lot of stuff here, like the big Oculus ZeniMax thing. That dealt with the software that powers VR, not the VR content. So yeah, luckily right now, litigation and action are pretty rare. If you mess up, please don't beat yourself up too much over or lose sleep. You're probably not getting sued. But do make sure that everything is licensed. One advice I have is always look for Creative Commons or open source licenses when bringing stuff in. Or the ideal is anything that's in the public domain. And you can always find a good amount of public domain stuff out there. Anything created before 1924 is public domain currently in the United States, and you can find some random stuff that lapses into the public domain for pretty stupid reasons due to old copyright law before that. I mean, if you want to show Night of the Living Dead, for example, it lapsed into public domain because they forgot to put a copyright notice on it when they distributed it. That was the really dumb law at that time. And also, like I was talking about earlier, do understand the limitations of fair use. Fair use cannot protect you from being sued, only from being held liable. So keep that in mind if you do choose to rely on fair use. Okay. Some great resources to find some free stuff. We all love free stuff. Free stuff is the best. 3D models, Sketchfab, CG Transfer, and Thingiverse all have large libraries of free-to-use 3D models. Some great stuff there. Software for doing 3D modeling. I have actually used Blender and Tinkercad both. I do more architectural stuff than this type of 3D design, but I've used both and I've actually enjoyed them both. And Wings 3D also seems to be highly recommended. I don't know much about that one. Images, I mentioned these earlier. Pixabay, Petzls, and Wikimedia Commons are all great. And if you want free-to-use music, archive.org actually has one of the largest free-to-use music libraries I know of. And, appropriately enough, it's called the Free Music Archive. I really don't know how much more self-explanatory a title can get. I mean, it's free, it's a music, and it's an archive of free music. It's not that difficult. But yeah, those are two very, very good resources to check out. Yeah. So, how to protect your work. Oh, I figured out how to get my slides back to me. Cool. All right, how to protect your work. This is, I know Laurel is very big on this part, so I had to make sure to give this at least a few slides worth of time. First step, when you create stuff, register your work. If you are in the United States, or you think you might ever want to consider suing someone in the United States, or need to take any kind of serious action in the United States, register your work. It's actually not that difficult. People like me can do it for you if you want to pay way more than you have to, but I recommend doing it yourself personally. Go to eco.copyright.gov, and they will literally walk you through it. It's especially simple if you have one work with one author. It's stupid easy. Believe me, you won't have much frustration with it. It is required in these United States if you wish to file a lawsuit. This is something that the United States is unique on. You do not see this anywhere else in the world because the United States is backwards in some ways. Imagine that. But if you want to file a copyright infringement lawsuit, you have to have the registration first. And if you have a timely registration, which means either within 3 months of publication or before the infringement takes place, you can greatly increase your damages by collecting statutory damages. And right now, a single application for the U.S. single registration costs just $35 at the U.S. Copyright Office, and others cost $55. That's more complicated ones like group registrations and whatnot. Now, this is where I got made to look like a jerk. After I finished these slides and sent them off and did all that great work, the U.S. Copyright Office sent out the memorandum that they're raising the rates. You bastards. I'm on to you. They did that just to make me look like a chump. I'm on to them. The long and short of it is that both of those prices are going up by $10 on March 20th. So if you're thinking about registration and you want to save a little dosh, get on that. You know what I mean? Get on it. So, how to protect your work. The main step to protecting your work is to search for it. A lot of people, they find out about their first infringements from friends or family who notice, hey, you know that great model you did? Yeah, I saw it on sale at this store. That's not how you want to find out. If you have work in a specific space, keep an eye on that space. Hey, it's kind of cool to see what others are doing. I mean, that should be fun anyway. But also keep track. But also it lets you keep track and maybe spot infringements of your work before other people do. Please note, on different VR platforms, this means different things. I've had familiarity, for example, with Second Life. I know that people there had to closely watch marketplaces and so forth there. But definitely keep track of said marketplaces, including those just on the internet. They might be places where you could run into some of your own content, maybe even, like I said, being sold. Always track for titles and similar works to yours. Like I said, different VR spaces, this is going to mean different things, but it should be trivial to do in general. All right. Next, learn how to submit a DMCA notice. Now, for this slide, I very, very nearly, just said cplagiarismtoday.com, but I thought that'd be a bit kitsch. So yes, the Digital Millennium Copyright Act, or DMCA, what it does in this particular area is it requires hosts to remove or disable access to allegedly infringing works. Once you submit a proper notice, they are obliged to remove it, or they might be held at least partially liable for that infringement. If they remove it, they're not held liable. So they have great motivation to cooperate with you here. Long story short, all you have to do is send a formal notice, email it in, the work gets removed. Now, Plagiarism Today, if you go to Plagiarism Today at the very top, I have a Stop Internet Plagiarism section. It includes a whole thing about everything from finding the web host to how to actually send the notice, and it also includes the stock letters you need. Basically, it's basically Mad Libs, except instead of putting in but, you put in the URL that you want to actually have removed. Or you can put in but and get laughed out of, whatever you were trying to do. All right. Also, if you're going to do VR as a significant part of your business, I would seriously consider hiring a lawyer. If this is a big business and a significant part of your career is creating things for VR, this might be a worthwhile step. It does not cost as much as people think. Getting a lawyer, putting them on retainer. Lawyers will give you free consultations. Most lawyers will sit down and give you up to an hour's of time for free. And take it from a guy who also has a free 1 hour consultation. You can talk about a lot in an hour. A whole lot in an hour. So this is a chance to know what you need and see if they can help you and what they can do with you long term. Pay them a retainer. That way you guarantee that they'll work a set number of hours for you without any further question. And basically this helps you both to avoid trouble and helps you deal with infringements is the idea. You get someone there who knows the stuff and can really help you avoid any issues. And my advice is find one that specializes at least somewhat in online copyright. I don't think you're going to find a VR copyright attorney, but you can definitely find several that specialize in internet copyright issues, and they are probably your best source. So to quickly recap what we did here, one, we did talk a bit about me because, yes, I am that guy. We talked about the basics of copyright. We talked about how it applies to VR, and we talked about how not to get sued, hopefully. Don't screw up. And we talked about how to protect your work a little bit. So, yeah, I'm going to kick it over to questions now. I think we're allowed about 15 minutes, almost perfect.
Yeah, you did awesome. I love it. So, first of all, I'm going to hit the raise hand button, but let's give it up some joy here for the amazing Jonathan Bailey. I mean, my buddy, you are awesome. All right, well done. And considering you're in a jury-rigged system, to be able to make your way in here without violating a single
Look, you don't want me in on the selfie challenge.
Actually, I want to see that. All right. So, anyone have a question for Jonathan Bailey, the king, the queen, and the great diva of all things copyright? Jim, you have a question?
Yes, Jonathan, fantastic presentation.
Thank you.
Can you comment, one of the things that's disturbed me is in following these issues is organizations and individuals that are aware of how our legal system works and that it takes deep pockets to even defend work. What are the strategies as entrepreneurs that do not have or have a limited budget? You cannot keep an attorney on retainer for a very long time. What are the strategies that they can use to defend their work?
The DMCA takedown system I talked about at least briefly there, and I know, God, this was such a blow through of everything. I felt like a tour of my entire 15 years in 1 hour. But the DMCA system is probably your front line of defense. I help a lot of entrepreneurs use it. It's very cost effective to either have someone else send the notices or to send them yourself or have someone on staff send them. Long story short, if you send them yourself, it's free. It's just the cost of your time. And believe me, the time cost is kind of high on the first one, but by the second, third, fourth, definitely by the time you've done your 100th, it's super fast. Yes, it only gets content removed. It doesn't result in litigation, but one thing I have found that's been pretty consistently true is there's enough low-hanging fruit that infringers typically will move on to a different target. There's enough people who don't do anything to protect themselves that even just doing DMCA notices is enough to disturb. So that's where I would start with that. And within the DMCA, there are other things you can do, things known as DMCA subpoenas, in which you can use to get the identities of suspected infringers. That's something I didn't discuss in there because it's kind of a more situationally useful thing, but that also is extremely cheap. It's a subpoena that only has to be signed off by a clerk of court, and doesn't cost a great deal of money. So yeah, you are right. The legal system, especially if you're dealing with someone that's international or not geographically close to you, can be very costly. But luckily, those tools at least give you something to fight back on the lower end of the cost spectrum.
Excellent. Jim, was that good answer? Oh, Jim's just good. Okay, let's go to the next one. It's Bob.
Poor Jim.
Sorry, no, he turned off. Bob?
Search party for
Yeah,
Jim.
there,
We gotta find Jim.
Now we're doing Feral Bob. Bob. Yes.
Oh.
Hey, Bob.
Hey, Bob.
Good evening. So I've got a Canadian context to throw out. So just one shout out for fellow Canadians in the room. For any intellectual property questions, check out CIPO, the Canadian Intellectual Property Office. They can have lots of guides on things. But my question to you is, with the ratification of the Canada, US, Mexico trade agreement, or USMCA, depending on your government's preference on what it's called, is there any changes to copyright law coming down the pipe as those treaties are ratified that people need to kind of consider?
Interestingly, not significantly. There will be an extension of the copyright term in Canada, as I understand. There'll be Canada, I think, is currently a 20-year shorter term than the United States. They're moving up to the exact same one. They're harmonizing that. I'll get the word. Blah.
That's all right. I do it on a daily basis.
Harmonizing that. And interestingly, one of the things that had the potential to change was right now I talked about the DMCA and the notice and takedown system. Canada does not have that. They have a notice system where you submit a notice of infringement and they simply forwards it on. They have no obligation to remove. There was talk when the treaty was being negotiated that they were going to try to push Canada to change that, but they have not. They have exempted that. Canada can continue with the system it has. That was one of the big changes people were thinking was coming. But yeah, there doesn't really seem to be anything major, especially in the United States, because the United States is the country, because we're the world's bullies, it seems. We change other people's laws to match ours, not the other way around.
Agreed.
Okay.
Agreed. Wonderful. I have a question for you while we're waiting for anybody else who has a question. Compilation. So when you're building things in VR, you're often bringing things in from a variety of sources, as well as adding your own and making it original. What about the compilation issues with copyright?
Okay, that always gets into a bit of a weird space, and it can get very, very confusing, because yes, like for example, the comparison that leaps to my mind is scrapbooking or collage making is the natural sort of IRL analog to this. You can definitely have copyright in a collage or a scrapbook as long as there's that requisite level of creativity. But that, as we've noted, if you're looking at the fair use issue, are you creating something that is an infringement of someone else's book? It's very possible to create something that you both have a copyright in, but is simultaneously an infringement of someone else. And so that's the thing you have to be careful about. Is that when you're doing this, you're making a proper use of the content that you are including. As long as you are highly transformative and not trying to replace or not harming the market of the original works included, it's usually not going to be an issue. But once again, I don't want to be the defendant of a lawsuit ever, especially a copyright lawsuit. So it's something to be mindful of and be careful of. The safest approach is to make sure all the things you include are licensed correctly.
Now, something that I hear over and over again by people who are building worlds and doing events is that it's okay to get a picture off of the internet because, after all, it is free, and put it in my virtual world or event space because who's going to see it? How do you address that one?
I would say to anyone that says that, a very simple thing, you have a very dim view of the future of VR. There.
Well
because
said.
if you believe that VR is the way of the future, that this is going to be a big part of our lives, who's going to see it is one of the stupidest arguments you can make to that. I mean, it's just the truth. because this is going, like I said, and they're absolutely right. Right now, VR is still kind of niche. There's not a lot of legal battles over. There aren't photographers jumping in the VR worlds and finding their artwork being used, and those that aren't necessarily doing anything, doing anything about it. But as VR grows, as VR becomes more commercially viable, as more things take place in VR, this is going to be a growing issue. And I say it's better to learn good habits now than to wait for the lawsuits to fly.
Yay! Amen on that. And all right, we have a question, and I have another great question. All right, Nira, you're on. Hey, friend.
Hello.
Hi, Nira.
Yes,
Hello.
my question is kind of like about building in here as well. You see things happening. We even had a world we built that has some songs in it. I don't know if many people are in Jump Park, so it's like, we don't know what to do with that. Rip all of the songs out of there, or, it's like, this starts off as something where it seems like just a fun place to hang out and things like that, and then it's like, are we going to get sued eventually over fun worlds that we're making? And
Yeah, and
Now, I want
and
to
I'll say
explain something,
this.
Jonathan. In that particular
Yes,
case,
please.
in that world, there's just a little bit of a snippet. It's not the full song.
Yeah.
It isn't just.
Yeah, it's snippets.
No, is it the full song? Ben,
I
is it
believe
the
it
full
is
song?
a full song on them.
Yeah.
Okay, all right, I guess it is. Okay.
Okay, I would say that the prospect of you getting sued is unlikely. Lawsuits are incredibly rare, ultimately. They are very, very rare. Legal threats are, let me put it like this. I get legally threatened probably about once every month. I've never been sued. To give you a taste of the pattern there. So, yeah, I basically have a lawyer that I keep on retainer, and that retainer is beer. I pay for his drinks. That's my
as it
pro tip.
grows-
Befriend a lawyer and pay him in beer. It works amazingly well.
As it grows, though, and there's talk about monetization
Yeah.
within some of these spaces,
Yeah.
it is like kind of something we're concerned about. And I mean, even
Yeah.
you making the comment about
Yeah,
you're
exactly,
videoing
and
this,
that's-
and then this video belongs to you for content. But then there's people in every space videoing your content too, and uploading it to YouTube. It's like, where are the lines on all of this?
Yeah, and that's one of the reasons why this was one of the most difficult talks I had to write, was because there's not a lot here. There's not a lot of history. You look into case law and VR and so forth, you don't see much. This area is still very, very new, and the law has definitely not caught up to it. There's a saying that the law is typically speaking about at least 20 to 25 years behind the tech. And by that standard, the law just caught up to GeoCities, which I think is probably about right.
All right. Zeke, you have a question.
so
Yeah, you're right.
Yes, I missed the most of this event, unfortunately.
Oh.
But I do
Okay,
have
no
a
problem.
question about how about fan projects, and how that is copyright, how that's not plagiarizing, but you're still using that
Okay.
IP in that area.
Oh,
Fan-
that's
okay.
it.
Fan
So I want to
projects
give an
are-
example. Yeah, but I want to give that, Zeke, that is an
Okay, go
awesome
ahead.
question. So we have some worlds that are built on Harry Potter themes, and you brought up J.K. Rowling, and
Yeah, of course.
and so, but they're theme based, but they are original things that are created into it. But there's Unity products that have Unity designs that people have imported in that are based on trademark fan things. So where does fan come in? I think it's a great question.
The issue of fan creation, and this is something that's been going on online ever since the old Usenet days in which people were writing Star Trek fan fiction at alt.startrek.fanfiction, I think it was. Don't ask how I know that.
We're fans. We're fans. Okay, I'm
But
sorry.
yes, the point is, fan fiction has always been an issue, and the reason for that is because fan fiction is technically a copyright infringement, pretty much constantly. Now, that said, most creators understand, hey, this isn't hurting us, so they either have a formal or an informal policy of allowing it. And the result of that is most creators, including, you would think Paramount would be like the biggest jerks on the planet, But it wasn't until someone went and got like $1 million to fund a fan movie they actually did anything about it. It actually really took a stand, and they were probably right to do that one. That was a bit OTT. But the long and short of it is, creators have a lot of leeway. J.K. Rowling, by most accounts, seems very chill about this. Not-for-profit fan fiction, she's very cool with. She did shut down the Harry Potter Encyclopedia because that was a for-profit project. And I think she allowed it to be released as a charity project or something like that. Now, there are other creators like Anne Rice, who is notoriously not like J.K. Rowling.
Yes.
She will come at you with a hammer and a nail gun if you start doing fan fiction of her stuff.
Yeah. Yeah.
So,
yep, that's her.
So the main thing to do is sort of take a look at the fan fiction community, look at what's been normalized, and understand that, yeah, you're doing this at the good grace of the original creators and who holds in the rights holders. But like I said, most have learned it's not smart to go to war with your fans needlessly. So non-commercial fan creations typically are pretty well tolerated, even if they are technically infringements.
Okay, so I want to get to that's a fantastic question. I want to get to another question. We're going to let this just run just a little bit more. If anybody has any questions, there is another event that is starting up, but the speaker is a little bit late, so don't be in a rush to dance out there. Now, we talked about compilations and fan fiction and things like that. Now I want to talk about something that might be a little more complicated. So let's say that...
Oh, more complicated.
More complicated, okay? So let's say that
Sure.
a world builder has created a world for, let's say, an event. Okay, that makes the best sense. So they're creating it for an event. And then they get in a little bit of the person they built it for, and it wasn't under contract, it wasn't anything, but they get in a bit of a stink, because relationships, VR relationships are no different than in the real world. People have a fight. And so they then decide to shut down that world building event and stop the other people from using it because they own the copyrights. Now, I'm not saying that's good or bad or anything, but when you own those rights and then you want to discontinue those rights, where's the line for people who host an event and they make that agreement to have an event, the world built for them? How does that all, that's all mixed up, and we've had quite a few of those every once in a while. There's a thing like that. Where's the law stand? Or does it?
Okay, so long story short, I'm trying to make sure I understand what happened before I start shooting my mouth off. So
Go ahead,
people are working on creating an event, and the person who owns the rights to it shuts it down due to a disagreement with the people who were helping and contributing to it in one way or the other. There's an old saying that just because you're being legal doesn't mean you're not being an asshole.
Okay, not what I thought was going to be your answer.
But if you own the rights
Beautiful.
to something, obviously you have, and this is something underneath what is known as moral rights. It enters into a little bit of that because it's not so much a U.S. thing, admittedly, but elsewhere in the world, there's something known as moral rights, which gives a creator/rights holder, or it's usually the creator in most countries, but it gives the creator of something the right to always be attributed to it, the right to have their name removed from it if they wish, and also the sole exclusive right to destroy it. This way, if you buy a painting from some artist, you can't just take it out back and run over it with your car, because they have moral rights over that painting and can prevent it with why you would do that, I don't know.
Connie, there's some
you're making a
paintings,
YouTube
but
video.
anyway.
You're making a YouTube video. I don't know. But the point is, you can prevent that through moral rights. But yes, if they're the ones with the rights to it, they have the right to shut it down and to stop it. But you're right. That doesn't make it fair if other people are contributing and working on it. Now, depending upon the type of contributions they're doing, they may have... There's joint authorship and joint creation under copyright. So if Laurel and I decide we're going to write a book together, to give just a simple example, and so we both pen a couple of chapters and we edit each other's stuff. We both make a lot of contributions. And our stuff's getting really commingled. Here. And because I'm a known jerk, decide, no, screw this, and I yeet the thing into the trash and delete it forever. you still have half the copyright. And so if you still have access to it in some way, you are
I have
able
access
to
to
enter
half
into
of it. I can get out the scissors and I can cut it in a knife. But
Well, no, you can. No,
Yeah.
as half author, you actually have the rights, the whole thing. You just can't enter into any exclusive agreements without me, and you have to give me a full accounting of any money you earned, and I get half of that money. So it works a joint authorship, but like I said, that depends upon the nature of the contribution, and I know in VR especially, it can be dubious as to whether or not a contribution to something qualifies as a contributing to the copyright of it. So that's why I'm a little bit hesitant to go that far. But yes, there are works of joint authorship, and that joint author does have the right to continue to use the work, the full work even, but only if it's a true work of joint authorship.
wow, that is fascinating. Bob, you have another question, then Larry Rose, and then Larry's off. Okay, so Bob, it's you.
Sure. This might fall under other rights issues, as you were just
Okay,
kind of.
I'll give it my best.
Given that we can, change our avatar, what's the kind of rules and policies in place regarding if I wanted to be a famous person and take their likeness? Does that fall under copyright if I was taking very stylistic issues or things that they use to represent themselves? Or is it another moral rights issue where I say I want to be a kind of famous person?
It strangely isn't related to what's known as an intellectual property right. And by the way, why would you want to change your avatar? You're smashing. Never change that.
You say the
Excellent.
sweetest things.
Yes, excellent answer. Yes.
But it actually falls under the right of publicity, which interestingly enough falls under defamation and libel, specifically libel, rather than libel and slander, rather than because if I wanted to pretend to be Keanu Reeves, which would be
You
awesome.
look so much like him right now.
No, I do. But if I wanted to be Keanu Reeves and pretend to be him, I would be essentially in many ways defaming him because he would not actually be doing the things that I did. And I would hug all the babies and save all the puppies from burning buildings and so forth, but still it would not be Keanu Reeves. And the result of that is it could be seen as libelous toward him. So it actually, and celebrities in particular, since they have a commercial right in their character, they have a right of publicity. So if you were to do anything commercial, especially, while looking like or pretending to or alluding to the fact that you are a celebrity, that's a violation of a commercial right there, but it's the right of publicity, and that's a little bit outside my wheelhouse, but it's a really fascinating area of law.
It is. Yeah, when
and
you push
would
into
there be-
defamation and libel, it gets complicated.
And is there elements of like parody, for like Saturday Night Live?
Oh, yeah. Exactly,
Various
yeah.
exemptions from that kind of stuff. Yeah. Okay.
Yeah, there's definitely parity and so forth in that. The long and short of it is, it's a matter of whether or not people believed that you had a relationship with that person that you did not, and you being that person is probably the most intimate relationship you can indicate you have with someone. That would be a lie. Once again, if I pretend I'm Keanu Reeves, I've never met Keanu Reeves, and I'm definitely not him. That's a relationship that is untrue. But if I said, hello, everyone, I'm Keanu Schmeeves, and stammered around drunkenly and did all this stuff pretending to be him, that would parody, because you wouldn't actually believe that I'm indicating I'm Keanu Reeves.
Wonderful. I love it. Oh, all right, Larry, you're off again. So hit the raise hand once. Larry Rose, if you have a question for Jonathan Bailey, this will be our last question. Okay, now don't touch that thing again. Okay, Larry Rose.
Can you hear me?
Yes,
Great.
we
Yes.
can.
Oh, I'm clear.
Hi. I just wanted to make a couple of quick comments. Most of the advice has been great. There has been a good deal of history in a lot of avatar worlds. Some of the questions, Second Life, Star Dolls, IMVU. These are virtual world communities, mostly user-based. Most of these issues have actually been litigated many times in them, especially the fan issues or the trying to avatars that look like people and selling them, making businesses out of that. I mean, there are literally millions of dollars have been invested in all those areas. So And Stardolls was a virtual world that was built out of the U.S., out of U.S. law, on the images of U.S. celebrities or world famous celebrities. So, my advice too, I've been doing this 25 years, virtual reality, selling objects and original content and copyright. So make it yourself, to be sure. And doing fan work.
That's good advice.
Make it educational and don't sell it. The other thing about the platform issue, you mentioned about doing exhibits, and I've done a lot of trade shows, virtual reality trade shows for many years too. Remember, we're all in a platform here that Microsoft owns. There's a TOS that we've all signed to be here. You may find that everything you think you are doing here that is yours is already theirs just by being here. So
to let you know that Microsoft and AltSpace have it in the TOS, because I read it through, because I've been trained very well by my dear friend Jonathan Bailey. You own original content that you create here, but you are licensing it for open use. So
Which
is
that's very typical. But
understand that also will change, and also what open use is will change. If these platforms monetize, I can tell you that during the life of Second Life,
absolutely.
Originally, models that one built. If somebody built an original design for an airplane and started to monetize it, then all of a sudden somebody wanted to use that airplane in a music video. Okay, and it's called an original cartoony design. This actually happened to me. So it was actually a spacecraft, but it was then used in a commercial music video. They bought it and used it in a commercial music video out of Brazil. And under the rights inside of the renewed TOS, because TOS has changed constantly, anything that was filmed in the world, machinima was the term, some people maybe still know, could be used legally under you giving the license to Linden Labs to then transfer that license. So, Johnson's correct. Is correct. I mean, these are this part of VR is a whole new world again, but there is legacy to it all, and once dollars start flowing into it, that legacy will all come right back.
Yep. Okay. Good point.
Yeah, wonderful presentation, by the way.
I added you as a friend. I'd love to chat with you more about this sometime, because I think you got some good input that I'd love to maybe codify into an article for PT.
I did, I think, but yeah, I'd love to, again, I've been popping in here.
That's another time, not necessarily right now.
No. I understood that. I friended you, so.
Okay, sorry.
Yeah. All right, thank you, Darius. All right, on that note, I guess we have Carlos Acevedo is on right now. He's finally shown up. He's a little bit late. He had technical difficulties. So right now in another room is the Positive Environment, Creating a World Around You, is a teaching tool through virtual reality, and he is the founder and CEO of Event Horizon Experiences. Coming up in less than 45 minutes is the cyberbullying panel. Myself, John Williams, and Brendan Hatton are going to be talking about one of my favorite subjects, and that is beating up avatars. No, we're going to be talking about cyberbullying and how that works here and other things. Yeah, no,
I'm trying to bully Lorel.
Oh, you're trying to bully me, honey. You've been doing it for years, and I enjoy it too much.
Oh,
I love it. I'm sorry. I'm being sicko here. Anyway, let's start when you're with one of your besties. It's just, don't you just kind of sink into that right away? All right. Thank you, everybody. Round of applause for the amazing Jonathan Bailey. Oh my God, you are amazing. I love you so much. You're just revolutionizing this tremendously. And if you have time, my friend, if you want, you can just hang out here.